another episode of Talk Talks. Again, I am Cherry Blossom, and as requested by most of our listeners, today's discussion would be about the organizational structure, the powers and duties of the Bureau of Internal Revenue, and more on the prescriptive periods for tax assessments. So I have here with me Ma'am Kathy, Ma'am Freda, Ma'am Ashra, Sir Bon, and Ma'am Caris. So they would be here to help us and shed some light on this topic. So, Ma'am Freda, do you have anything else to say?
Yes, hello everyone. Let's get right into it and look at the organizational structure of the BIR. But if you would notice, most cases involving taxes would have the CIR as either the petitioner or defendant. This is because the BIR is actually headed by the Commissioner of Internal Revenue. So he is appointed by the President upon the recommendation of the Secretary of Finance. Now let's check if you all know this. Who is our current Commissioner of Internal Revenue?
Oh, I know this. It's Romeo Lumagi Jr., right?
Oh, that's right.
And he actually has four assistant commissioners who are also known as deputy commissioners. We have Maridur Rosario, the deputy commissioner for the operations group, Marisa Cabreros, the deputy commissioner for the legal group, Maria Rosario Charo G. Enriquez Coriba is the deputy commissioner for the information systems group, and of course, Teresita Angeles, the deputy commissioner for the resource management group.
Oh, Ma'am Kathy really came prepared tonight.
And wait, there's more. Under them, we also have revenue district officers, regional directors, the revenue examiners and officers, and the division chiefs of the BIR, and lastly, the BIR collecting agents.
So that's how the BIR's organizational structure looks like. So I think our viewers also would like to know what exactly are the powers and duties of the BIR.
Well, I can answer that for you because Kathy is not the only one prepared. Char. So, the powers and duties of the BIR are actually in Section 2 of the NIRC. So, we have four. The first one is the assessment and collection of all national internal revenue taxes, fees, and charges. The second one is enforcement of all forfeitures, penalties, and fines connected therewith. Third is the execution of judgments in all cases decided in its favor by the Court of Tax Appeals and the ordinary courts. And lastly, the fourth one is the administration of the supervisory police powers conferred by the NIRC and other laws.
All right. So this would bring us to the more interesting part of the discussion, the questions from our listeners. So, in line with the BIR's power to assess and collect taxes, is the consent of a taxpayer needed before his pertinent documents may be received by the BIR and used in arriving at a tax assessment?
So the answer to that is no. We have the 2008 case of fitness by design versus CIR that explains this. In this case, the CIR assessed the records of fitness by design received by it from Sablan, BIR's informer, without the consent of fitness. And the Supreme Court held that the law allows the BIR to access all relevant or material records and data in the person of the taxpayer. And the BIR can accept documents which cannot be admitted in a judicial proceeding where the rules of court are strictly observed. To require the consent of the taxpayer would defeat the intent of the law to help the BIR assess and collect the correct amount of taxes.
Correct. In fact, the BIR has the authority to obtain on a regular basis from any person other than the person whose internal revenue tax liability is subject for audit or investigation, and to summon any person having possession, custody, or care of the books of accounts and other accounting records containing entries relating to the business of the person liable for tax or any other person to appear before the commissioner or his duly authorized representatives to produce such books, data, records, and to give testimony in accordance to Section 5 of the NIRC.
Well, this was also reiterated in the 2010 case of CIR versus Raul Gonzalez. So in this case, the BIR assessed the Camus Engineering Corporation for the taxable years of 1997, 1998, and 1999. And based on the information that the Camus Engineering based on the information, Camus Engineering had substantial undeclared income for the said period. And based on the data obtained from an informer and various clients of the Camus Engineering, it was discovered that the engineering corporation filed fraudulent tax returns with substantial under declarations of taxable income for the years 1997, 1998, and 1999. So in this case, the court held that revenue officers are authorized to gather information from third parties. The lack of consent of the taxpayer under investigation does not imply that the BIR obtained information from third parties illegally, or that the information received is false or malicious, nor does the lack of consent preclude the BIR from assessing deficiency taxes on the taxpayer based on the documents.
Yes, indeed. It also held in this case that the respondents cannot be allowed to escape criminal prosecution under Section 254 and 255 of the NIRC by mere imputation of a fictitious or disqualified informant of the Bureau.
Okay, so that settles the first question. So moving on to another question from our listeners. So can the CIR delegate the authority to make tax assessments to subordinate officers?
Yes, definitely he can. The authority to make tax assessments may be delegated to subordinate officers. So this was established in the case of Oceanic Wireless Network Incorporated versus CIR in 2005. So in this case, Oceanic questioned the demand letter for tax deficiency assessments issued and signed by a subordinate officer who was acting in behalf of the Commissioner of Internal Revenue. Should be deemed final and executory and subject to an appeal to the Court of Tax Appeals. And the court said the general rule is that the Commissioner of Internal Revenue may delegate any power vested upon him by law to division chiefs or to officials of higher rank. He cannot, however, delegate the 4 powers granted to him under the National Internal Revenue Code enumerated in Section 7. So I'll just enumerate those. The first one is the power to recommend the promulgation of rules and regulations by the Secretary of Finance. The second is the power to issue rulings of first impression or to reverse, revoke, or modify any existing ruling of the Bureau. Third, the power to compromise or abate under Section 204A and B of the National Internal Revenue Code any tax deficiency. And lastly, the power to assign or reassign internal revenue officers to establishments where articles subject to excise tax are produced or kept. So it is clear from the provision I just stated that the act of issuance of the demand letter by the Chief of the Accounts Receivable and Billing Division does not fall under any of the exceptions that have been mentioned as non-delegable.
Yes, furthermore, Section A of the NIRC stipulates that after a return has been filed as required under the provisions of this code, the commissioner or his duly authorized representative may authorize the examination of any taxpayer and the assessment of the correct amount of tax, provided, however, that the failure to file a return shall not prevent the commissioner from authorizing the examination of any taxpayer. Thus, the authority to make tax assessments may be delegated to subordinate officers. Said assessment has the same force and effect as that issued by the commissioner himself, if not reviewed or revised by the latter, such as in this case.
Okay, thank you for that very detailed answer. And the next question would now involve assessment of real property taxes. So the question goes this way. Um, can or Okay, our listeners are asking whether the BIR has the power to unilaterally change the zonal valuation of properties without first conducting a re-evaluation of the zonal values.
Well, to our listeners who possess real properties, listen very well. You should know that the BIR cannot unilaterally change the zonal valuation of properties without first conducting a re-evaluation of the zonal values. This is clearly established in the case of CIR versus Aquafresh Seafoods Incorporated. So in this case, Aquafresh sold to Phillips Seafoods 2 parcels of land classified as residential lots. When Aquafresh filed its return, the BIR received a report that these lots were sold undervalued for taxation purposes. After investigation, the BIR concluded that the subject properties should be classified as commercial. However, the court held that BIR cannot reclassify such lots without the proper consultation with competent appraisers both from the private and public sectors, and determine the fair market value of real properties located in each zone or area. Also, the predominant use of other classification of properties located in a street or barangay zone, regardless of the actual use, shall be considered for purposes of zonal valuation. Even assuming arguendo that the subject properties were used for commercial purposes, the same remains to be residential for zonal value purposes. It appears that the actual use is not considered for zonal valuation, but the predominant use of other classification of properties located in the same zone.
Okay, so in addition to that, Revenue Memorandum Number 58-69 provides for the procedures on the establishment of the zonal values of real property. So these are the following. First, the submission or review by the Revenue District Offices, Sub-Technical Committee of the Schedule of Recommended Zonal Values to the Technical Committee on Real Property Valuation or TCRPV. The evaluation by TCRPV of the submitted schedule of recommended zonal values of real properties. Third, except in cases of correction or adjustment, the TCRPV finalizes the schedule and submits the same to the Executive Committee on Real Property Valuation or ECRPV. Now, the fourth one is, upon approval of the schedule of zonal values by the ECRPV, the same is embodied in a department order for implementation and signed by the Secretary of Finance. Thereafter, the schedule takes effect 15 days after its publication in the Official Gazette or in any newspaper of general circulation.
All right. I hope the listeners really listen very well. So we also have a question here asking whether the BRR can make use of the taxpayer's delay of submitting the required documents as an excuse to issue an assessment beyond the 3-year period.
Well, the short answer to that question is no. And the CIR actually has the power to make assessments based on the best evidence obtainable. Let's look at the case of CIR versus Kudos Metal Corp in 2010, for instance. So what happened was the BIR issued an assessment to Kudos after the prescriptive period to assess the taxes has lapsed, claiming that it was due to the delay of Kudos to submit the pertinent documents as an excuse for issuing the assessment beyond the prescriptive period. However, in that case, the court ruled that the BIR cannot use this as an excuse for issuing the assessment beyond the 3-year period because with or without the required documents, the CIR has the power to make assessments based on the best evidence obtainable.
So, picking up on that prescriptive period, our next topic would be focusing on prescriptive periods. So, what then is the meaning or what is then period of prescription?
So Section 203 of the NIRC mandates the government to assess internal revenue taxes within 3 years from the last day prescribed by law for the filing of the tax return or the actual date of filing of such return, whichever comes later. Exceptions, however, are provided under Section 222 of the NIRC. So, in the case of Republic of the Philippines versus GMCC United Development Corporation or Company, decided in 2016 that in this case, it made clear that in ordinary circumstances, the prescriptive period is 3 years from the last day prescribed by law for the filing of the tax return or from the day the return was actually filed. However, if the tax return is false or fraudulent, the prescriptive period is 10 years.
The court also had the same pronouncement in the case of CIR versus Goodrich Philippines involving the assessment of deficiency of the donor's tax. Are you familiar with this case?
That sounds familiar, but can you help us remember what happened in that case?
So the central issue in this case was whether the BIR's assessments for deficiency of donors' tax were subject to the statute of limitations. So the assessments were made several years after a land sale by the corporation.
Did the court uphold the BIR's assessments or side with the corporation?
So in this case, the court ruled in favor of the corporation. They held that the assessments were barred by the statute of limitations because they were issued after the 5-year prescriptive period had expired.
Well, that's interesting. Was there any specific legal reasoning the court used to reach that decision?
Yes, the court based its decision on the provisions of the NIRC, especially Section 331, which sets a 5-year prescriptive period for assessments. The BIR couldn't demonstrate that the assessments fell under any exception to the prescriptive period as outlined by the law.
I see. But what about the BIR's argument that the taxpayer's return was falsified? As mentioned by Chris earlier, if the return is false or fraudulent, the prescription becomes 10 years. Isn't that applicable in this case?
Well, the BIR's claim of falsity in the taxpayer's return wasn't sufficient to extend the prescriptive period. According to the court's ruling, the assessments were issued after the 5-year limit had expired, and that took precedence.
So that is a good reminder of the importance of adhering to tax laws and time limits for assessments. So this case seems to reinforce the concept that there are rules and limitations in place for a reason.
Absolutely. And it also highlights the significance of understanding the specific provisions of the tax code, as they can have a significant impact on the outcome of tax related disputes.
Precisely, this case underscores the importance of following the law and ensuring that tax assessments are made within the prescribed time limits to avoid potential disputes and penalties.
But has the prescription period always been 3 years?
In fact, it hasn't. So prior to the amendment of the prescriptive period, the prevailing rule on prescriptive period was 5 years. Now, the case of Asnar versus Court of Tax Appeals, decided in 1974, is quite illuminating. It stated that the ordinary period of prescription of 5 years within which to assess tax liabilities under Section 331, which is now Section 221 of the NIRC, should be applicable to normal circumstances. But whenever the government is placed at a disadvantage so as to prevent its lawful agents from proper assessment of tax liabilities due to false returns, fraudulent return intended to evade payment of tax, or failure to file tax returns, the period of 10 years provided for in Section 332A and now is Section 222A of NIRC from the time of the discovery of the falsity, fraud, or omission even seems to be inadequate and should be the one enforced.
So if the period of prescription now is 3 years, what would be the reckoning point within which to compute it?
To answer that, we have the case of a CIR versus Transitions Optical, decided in 2017, wherein the petitioner argues that the assessment required to be issued within the 3-year period refer to the petitioner's actual issuance of the notice of assessment to the taxpayer, or what is usually known as PAN or PAN, Preliminary Assessment Notice, and not the FAN or the Final Assessment Notice issued in case the taxpayer files a protest. So it is a PAN versus FAN. The Supreme Court held that prescription had already set in at the time the final assessment notice and the final letter of demand were actually mailed to the taxpayer. So the reckoning point for prescription to set in is the service of the FAN upon the taxpayer and not the preliminary assessment notice.
So what was Ma'am Chris was saying is between a pre-assessment notice and a final assessment notice. So what about now? In case an original return was amended, what then is the basis in computing the prescriptive period?
Well, in that case, that issue is answered by the case of CIR versus Phoenix Assurance. This was decided in 1965. So in this case, it provided that the amended tax return should be the basis in counting the prescriptive period because there are already substantial modifications of the original return. So to hold otherwise, the courts would be paving the way for taxpayers to evade the payment of taxes by simply reporting in their original return heavy losses and amending the same more than 5 years later, when the Commissioner of Internal Revenue has already lost his authority to assess the proper tax thereunder.
Yeah, that's quite logical din naman. So moving on to another question. Is the prescriptive period applicable to all taxes?
So I remember one case where it said that it is not. So it's the case of the Commissioner of Internal Revenue versus Ayala Securities Corporation. So in that case, the CIR assessed Ayala Securities and Commission for 25% surtax on February 21, 1961 for its fiscal year ending on September 13, 1955. So we can see here the prescriptive period at that time was 5 years.
Oh, so it seems that Ayala was assessed in the 6th year. I'm assuming that Ayala is claiming that the 5-year prescriptive period to assess has already expired.
That is correct. So it was held in that case that the period of limitation upon assessment and collection stated under Section 331 and Section 332A of the National Internal Revenue Code is only applicable to situations where the taxpayer is required to file a return. So there is no law requiring taxpayers to file a return on their unreasonably accumulated surplus. So therefore, the right to assess and collect surtax is not subject to the 5-year prescriptive period. The limitations upon the right of the government to assess and collect taxes will not be presumed in the absence of clear legislation to the contrary, and that where the government has not by express statutory provision provided a limitation upon its right to assess unpaid taxes, such right is imprescriptible.
So, since there is no express statutory provision limiting the right of the CIR to assess surtax, then it is safe to assume that it may be assessed at any time.
Yes, there you go. Now, to reiterate, limitations on the right of the government to assess and collect taxes can never be presumed. There must be an express statutory provision to the contrary.
So I guess we are also safe to assume that we are clear on the prescriptive period and its reckoning point. Now, let's look into the exceptions that was mentioned earlier. Ma'am
So to
Asra?
start, yes, let's start with one of the exceptions in section 222 of the NIRC. And this is in the case of a false or fraudulent return with intent to evade tax or a failure to file a return. The tax may be assessed or a proceeding in court for the collection of such tax may be filed without assessment at any time within 10 years after the discovery of the falsity, fraud, or omission. Provided, however, that in a fraud assessment which has been final and executory, the fact of fraud should be judicially taken cognizance of in the civil or criminal action for the collection.
So another exception is if before the expiration of the 3-year period for the assessment of the tax, both the commissioner and the taxpayer have agreed in writing to its assessment after such time. The tax may be assessed within the period agreed upon. The period agreed upon may be extended by subsequent written agreement made before the expiration of the period previously agreed upon. So this is also known as waiver of the statute of limitations, which must strictly comply with the guidelines.
Okay, let's clarify the first exception. In the case of omission, false, or fraudulent return, is there a difference between falsity, fraud, or omission?
Yes, there's a difference in the case of our SNAR versus CTA. In this case, it was mentioned earlier, and it also provided that false returns merely imply deviation from the truth, whether intentional or not, while fraudulent returns implies intentional or deceitful entry with the intent to evade taxes that are due. Omission is, of course, the failure to file a return.
That's right. I remember the case of CIR versus Asalus Corporation, which also clarified what is considered a false return. So in that case, there was a substantial understatement in Asalus income, exceeding 30% of what was declared in its VAT returns. Thus, the CIR concluded that there was prima facie evidence of a false return. The CTA opined that the CIR failed to substantiate with clear and convincing evidence its claim that Asalus filed a false return. Therefore, the assessment was subject to the 3-year ordinary prescriptive period.
Okay, so is it necessary that the CIR present evidence to prove the falsity in the returns before the 10-year prescriptive period is applied?
Oh, well, not really. In fact, in the case it was held that when there is a showing that a taxpayer has substantially underdeclared its sales, receipt, or income, there is a presumption that it has filed a false return. As such, the CIR need not immediately present evidence to support the falsity of the return unless the taxpayer fails to overcome the presumption against it. Its failure to overcome the same warranted the application of the 10-year prescriptive period for assessment under Section 222 of the National Internal Revenue Code.
I see. So, in false returns, there is no need to present evidence. Rather, it is the taxpayer who needs to overcome the presumption of a false return. How about if it is a fraudulent return? When does it occur, and is there when does it occur? And is there also no need for immediate evidence?
Well, fraudulent returns, as discussed earlier, is different. So the tax return is fraudulent if there is failure to report an income in an amount exceeding 30% of that declared in the tax return, or there is an overstatement of deduction in an amount exceeding 30% of the actual deduction. So as declared in the case of Republic of the Philippines versus GMCC United Development Company, it is not enough that fraud is alleged in the complaint. For the 10-year period under Section 222A to apply, it is not enough that fraud is alleged again in the complaint. It must be established by clear and convincing evidence.
So I hope our listeners are clear on the difference between false and fraudulent returns with these clear explanations. So earlier, Ma'am Caris also mentioned another exception that may be the reason to apply the 10-year prescriptive period, and that upon a written agreement between the Commissioner of Internal Revenue and the taxpayer prior to the expiration of the 3-year prescriptive period, that written agreement is the waiver of the statute of limitations. However, it was said that it has to be strictly compliant with prevailing guidelines. What exactly are the requisites for a valid waiver of statute of limitations?
Yes, so for a waiver to be valid, it must strictly comply with RMO 20-90 and RDAO 05-01, which lay down the procedure for the proper execution of the waiver, and these are basically the 6 requisites. 1. The waiver must be in the proper form prescribed under RMO 20-90, that the phrase "but not after" the date, which indicates the expiry date of the period agreed upon to assess or collect the tax after the regular 3-year period of prescription, should be filled up. 2. The waiver must be signed by the taxpayer himself or his duly authorized representative. In the case of a corporation, the waiver must be signed by any of its responsible officials. In case the authority is delegated by the taxpayer to a representative, such delegation should be in writing and duly notarized. 3. The waiver should be duly notarized. 4. The CIR or the revenue official authorized by him must sign the waiver indicating that the BIR has accepted and agreed to the waiver. The date of such acceptance by the BIR should be indicated. However, before signing the waiver, the CIR or the revenue official authorized by him must make sure that the waiver is in the prescribed form, duly notarized, and executed by the taxpayer or his duly authorized representative. 5. Both the date of execution by the taxpayer and the date of acceptance by the Bureau should be before the expiration of the period of prescription or before the lapse of the period agreed upon in case of subsequent agreement is executed. And lastly, the waiver must be executed in 3 copies. The original copy to be attached to the docket of the case, the second copy for the taxpayer, and the third copy for the office accepting the waiver. The fact of receipt by the taxpayer of his or her file copy must be indicated in the original copy to show that the taxpayer was notified of the acceptance of the BIR and the perfection of the agreement.
So take note that the waiver has to strictly comply with all the requisites that Kathy mentioned. Otherwise, the waiver does not produce any effect. So the period for prescription is not suspended in that case. It will continue to run.
Cherry, I believe you're on mute.
I'm so sorry for that. um, I know that there are going back to the discussion. I know that there are quite a handful of cases where the validity of a waiver of statute of limitation has been the primary issue. So why don't we go over a few of them to help our listeners understand its application?
Right. So in the case of CIR versus Stanley Works, for instance, the waiver executed was deemed invalid since the waiver was not signed by petitioner or any of his authorized representatives and did not state the date of acceptance. The fourth and the fifth requisite being absent, the waiver is invalid. Furthermore, it was held that the BIR has the burden of ensuring compliance with the requirements, as they have the burden of securing the right of the government to assess and collect tax deficiencies. The waiver is not a unilateral act of the taxpayer, hence, the BIR must act on it, either by confirming to or by disagreeing with the extension.
So the case of CAR versus Philippine Daily Inquirer also reiterated that requisites for executing a waiver of prescriptive period are mandatory. In this case, waivers executed by the BIR and the PDI, which were meant to extend the 3-year prescriptive period. However, the waivers were defective. So the CIR failed to provide the office accepting the first and second waivers with their respective third copies, as the Court of Tax Appeals found them still attached to the docket of the case. As for the third waiver, it was not executed in 3 copies, missing the 6th requisite. So the 3 waivers in this case are defective and do not produce any effect and did not suspend the 3-year prescriptive period under Section 203 of the NIRC.
Yes, I also remember the case of CIR versus FMF Development Corporation, since it also involved a waiver of the statute of limitations executed by FMF Development Corporation for the assessment of their annual income tax return. So in this case, the BIR issued pre-assessment notices and FMF protested, requesting reconsideration. So FMF executed a waiver to extend the assessment period, but the BIR issued an assessment notice, which FMF protested, invoking the defense of prescription. Similarly, the Supreme Court found that it wasn't valid because it didn't comply with the procedures laid down in RMO number 20-90.
Um, may I just ask what were the specific issues with the waiver in that case?
So, in that case, the waiver wasn't signed by the Commissioner of Internal Revenue. It didn't contain the date of acceptance by the Commissioner. Lastly, FMF wasn't furnished a copy of the BIR accepted waiver. So the Supreme Court ruled that the waiver was invalid and didn't extend the original prescriptive period for assessing taxes. So as a result, the assessment was considered time-barred and it was canceled.
Another example is the case of CIR versus Systems Technology Institute. So similarly, the waivers executed by STI and CIR were deemed invalid. In this case, STI's Amiel Sangalang signed a waiver of the defense of prescription under the NIRC, extending the assessment and collection of taxes for fiscal year 2003 to later than December 31, 2006, which was accepted by BIR. However, the court found the waiver defective because at the time the first waiver took effect, the CIR's period to assess said taxes for 2003 has already prescribed as failing to meet the requirement number 5. Also, Sangalang has no notarized written authority, so it also failed requirement number 2. And lastly, the waivers did not specify the kind of tax and the amount of tax due, which was also a doctrine laid down in the case of CIR versus Standard Chartered Bank. Considering the said defects, the waiver executed did not extend the periods for the CIR to assess or collect the alleged deficiency taxes.
Okay, so let's add the 2019 case of CIR versus La Flor de la Isabela. In this case, La Flor executed 3 waivers consecutively, extending the period of assessment for its expanded withholding tax or EWT and withholding tax on compensation or WTC for calendar year 2005. When the assessment notices were issued, La Flor filed its letter of protest contesting the assessment notices, contending that the period of assessment already prescribed, whereas the CIR countered that it has not prescribed since La Flor had executed 3 waivers extending the prescriptive period under the NIRC and assailed that failure to comply with RMO number 20-90 does not invalidate the waivers.
So did that case change how non-compliance to RMO number 20-90 is perceived?
Well, not really. In fact, the court even added on to what is in RMO number 20-90 was stating that the waivers extending the prescriptive period of tax assessments must be compliant with RMO number 20-90 and must indicate the nature and amount of the tax due. These requirements are mandatory and must strictly be followed. In this case, the waivers fail to indicate the specific tax involved and the exact amount of the tax to be assessed or collected. These details are material as there can be no true and valid agreement between the taxpayer and the CIR absent this information. Clearly, the waivers did not effectively extend the prescriptive period under Section 203 on account of their invalidity.
Okay. By the way, RMO means Revenue Memorandum Order. So going back to the discussion, on numerous occasions, the court has consistently stressed that the requisites for executing a waiver of prescriptive period is mandatory. But how about estoppel?
I think we can talk about estoppel through some cases.
Yes, I remember reading about a case where a taxpayer was held estopped from questioning the validity of a waiver when it paid the tax assessment covered by that waiver.
So you are probably referring to the case of RCBC versus CIR. So in that case, Rizal Commercial Banking Corporation or RCBC, after filing its corporation annual income tax returns for foreign currency deposit unit for the calendar years 1994 and 1995, was subjected to an examination of its books of accounts and other accounting records for all internal revenue taxes by the CIR. Now, RCBC executed 2 waivers of the defense of prescription under the Statute of Limitations of the National Internal Revenue Code, covering the internal revenue taxes due for the years 1994 and 1995, which effectively extended the period of the BIR to assess. So RCBC then received an assessment notice, which shows that it had deficiency tax assessments amounting to 4 billion. RCBC disagreed with the tax assessment, so it filed a protest.
And RCBC received a revised assessment notice following the reinvestigation it requested, which drastically reduced the original amount of deficiency taxes of 4 billion to 303 million, right?
Yes, you remember that, right, Kathy? In that 303 million, RCBC paid the assessments for deficiency income tax, deficiency gross receipts tax, deficiency final withholding tax, deficiency expanded withholding tax, and deficiency documentary stamp tax, which is not an industry issue, amounting to 15 million. But it refused to pay the assessments for the deficiency onshore tax and the documentary stamp tax.
So in short, RCBC made a partial payment of the assessed deficiency taxes. So why then did RCBC refuse to pay the assessed amount for the onshore tax and documentary stamp tax?
Well, because RCBC argued that the waivers of the statute of limitations it executed were not valid because the same were not signed or conformed by the CIR as required under Section 222, Paragraph B of the Tax Code. Therefore, the right of the CIR to assess deficiency on short tax and documentary stamp tax for taxable years 1994 and 1995 had already prescribed.
Yes, so this is where the doctrine of estoppel comes in.
Among us, we know what estoppel is. But for the sake of our listeners, can you remind them again what estoppel means?
So the doctrine of estoppel is found under Article 1431 of the Civil Code. This doctrine is anchored on the rule that an admission or representation is rendered conclusive upon the person making it and cannot be denied or disproved as against the person relying thereon.
By disallowing a person from denying their own admission or representation against the person relying on such admission, what does the doctrine want to prevent?
A party is precluded from denying his own acts, admissions, or representations to the prejudice of the other party in order to prevent fraud and falsehood is what the doctrine of estoppel wants to prevent.
Right. So estoppel, therefore, is clearly applicable in the case of RCBC. So RCBC can no longer question the validity of the waivers of the statute of limitations because when it made a partial payment, it impliedly admitted the validity of those waivers. So had RCBC truly believed that the waivers were invalid and that the assessments were issued beyond the prescriptive period, then it should not have paid the reduced amount of taxes in the revised assessment.
That definitely makes sense. And in fact, the doctrine of estoppel is another thing that the court has clarified multiple times. So aside from the case that Freda was talking about, let's also look at the case of CIR versus Kudos Metal as another example. So in that case, the accountant of Kudos issued 2 waivers of defense of prescription consecutively for the assessment of its annual income tax return, that is for the taxable year 1998. However, when the assessment notices were issued, Kudos Metal Corporation challenged the assessments. This is because such assessments were issued beyond the 3-year prescriptive period. Then they claimed that the waiver executed by their accountant was also invalid due to the lack of written authority. So in this case, the court once again held that the waivers executed by the accountant of Kudos Metal Corporation did not extend the period within which the assessment can be made. At the same time, in this case, the CIR claimed that Kudos Metal Corporation is stopped from claiming prescription since by executing the waivers, it was the one who asked for additional time to submit the required documents. So Kudos Metal Corporation led the government to believe that the delay in the process would not be utilized against it. Thus, Kudos Metal Corporation may no longer repudiate the validity of the waivers and raise the issue of prescription.
That's actually a good point, but are they indeed stopped?
Well, the court ruled in the negative and said that estoppel does not apply in this case. So the doctrine of estoppel cannot be applied in this case as an exemption to the statute of limitations on the assessment of taxes, considering that there is a detailed procedure for the proper execution of the waiver, which the BIR must strictly follow. And as such, the doctrine of estoppel cannot give validity to an act that is prohibited by the law or one that is against public policy. It should be resorted to solely as a means for preventing injustice and should not be permitted to defeat the administration of the law or to accomplish a wrong or secure an undue advantage or to extend beyond them the requirements of the transactions in which they originate. So simply put, the doctrine of estoppel must be sparingly applied.
Right, because the BIR cannot hide behind the doctrine of estoppel to cover its failure to verify whether a notarized written authority was given by Kudos Metal Corporation to its accountant, and to indicate the date of acceptance and the receipt by the company of the waivers. Having caused the defects in the waivers, the BIR must bear the consequences. It cannot shift the blame to the taxpayer. To stress, a waiver of the statute of limitations being a derogation of the taxpayer's right to security against prolonged and unscrupulous investigations must be carefully and strictly construed.
Yes, that does sound familiar. If I'm not mistaken, it was also discussed in some of the cases that we just talked about involving non-compliance with the requisites of waiver.
You're right. So it was held in the case of CIR versus Stanley Works that the waiver of the statute of limitations, whether on assessment or collection, should not be construed as waiver of the right to invoke the defense of prescription, but rather an agreement between the taxpayer and the BIR to extend the period to a date certain, within which the latter could still assess or collect taxes due. The waiver does not imply that the taxpayer relinquishes the right to invoke prescription unequivocally.
Same is true with the case of CIR versus Philippine Daily Inquirer and CIR versus STI. It was consistently held that BIR cannot hide behind the doctrine of estoppel to cover its failure to comply with the procedure for executing a waiver, which was issued by the BIR itself. A waiver of the statute of limitations is a derogation on the taxpayer's right to security against prolonged and unscrupulous investigations, and thus it must be carefully and strictly construed.
Okay, so since the doctrine of estoppel cannot be applied, what can the BIR do in case assessment is still not possible, but the prescriptive period is fast approaching? What is their remedy?
Well, under Section 318 of the 1977 NIRC, CIR has 5 years from the time the excise tax returns are filed to 1. Issue an assessment and or 2. File a court action for collection without an assessment. So the law is saying that if an assessment is not possible within the prescribed period, there is an option to take judicial action for collection of tax within the prescriptive period since that does not require a prior assessment.
That is right. It was actually what the court said in the case of Commissioner of Internal Revenue versus Pilipinas Shell Petroleum Corporation. So in this case, the CIR seeks to collect from the respondents in the cases at bar pertain to the covered years 1992 to 1997, and during which the 1977 NIRC was the governing law. So the CIR failed to issue any valid assessment against Pilipinas Shell for the latter's alleged deficiency excise taxes for the covered years. So without a valid assessment, the 5-year prescriptive period to assess continued to run and had in fact expired in these cases. So irrefutably, the CIR is already barred by prescription from issuing an assessment against Pilipinas Shell for the deficiency excise taxes for the covered years. Resultantly, this also bars the petitioner from undertaking any summary administrative remedies such as distraint and/or levy against the respondents for collection of the same taxes.
Right. However, unlike summary administrative remedies, the government's power to enforce the collection through judicial action is not conditioned upon a previous valid assessment. Sections 318 and 319A of the 1977 NIRC expressly allowed the institution of court proceedings for collection of taxes without assessment within 5 years from the filing of the tax return and 10 years from the discovery of falsity, fraud, or omission, respectively.
Exactly. However, in this case, from the respondents' filing of their excise tax returns in the years 1992 to 1997, until the lapse of the 5-year prescriptive period under Section 318 of the 1977 NIRC in the years 1997 to 2002, CIR did not institute any judicial action for collection of tax as aforedescribed, without either a formal tax collection suit filed before the court of competent jurisdiction or an answer deemed as a judicial action for collection of tax within the prescribed 5-year period under Section 318 of the 1977 NIRC. The CIR's power to institute a court proceeding for the collection of Pilipinas Shell's alleged deficiency excise taxes without an assessment has already prescribed between 1997 to 2002.
Okay, I hope that is very clear for our listeners. So just because the taxpayer executes a waiver does not necessarily bar him from raising the defense of prescription if the waiver suffers from defects or is not compliant with the procedure and requisites. But other than a waiver, are there other ways to toll or suspend the prescriptive period from running? Sir Bon, you're
Uh,
muted.
there are other ways to toll or suspend the prescription period. Our laws provide numerous situations when the statute of limitations on collection may be interrupted or suspended. Another way is when a taxpayer taxpayer files a request for reinvestigation.
Oh, reinvestigation. That's quite specific. Does that mean that when a taxpayer files a request for reconsideration instead of a request for reinvestigation, the prescriptive period is not suspended?
You are right on that, Cherry. In fact, what you said was similar to what the Supreme Court had said in the case of BPI versus CIR. Now, in that case, BPI sold foreign bills of exchange to the Central Bank of the Philippines in 1985. Now, for such sale, the BIR assessed BPI in 1989 and found that BPI is liable for deficiency documentary stamp tax. In the same year, that is 1989, BPI protested the assessment, but they did not receive a reply to their protest letter right away. So in 1992, or 3 years after the 1989 assessment, BIR issued and served a warrant of distraint and or levy against BPI. Then again, BPI did not hear from BIR until 1997 when they received a letter denying the request for reconsideration.
It seems that the BIR treated the protest letter of BPI as a request for reconsideration. Just so everyone understands the terms reconsideration and reinvestigation, I believe it's best that we explain these terms first.
Okay, I'm quite confident to answer that. There are two types of protests. One is a request for reconsideration, and the other is a request for reinvestigation. So, first, a request for reconsideration refers to a plea for a re-evaluation of an assessment on the basis of existing records without need of providing additional evidence. It may involve both a question of fact or law or both. So a request for investigation, on the other hand, refers to a plea for re-evaluation of an assessment on the basis of newly discovered or additional evidence that a taxpayer intends to present in the reinvestigation. It may also involve a question of fact or law or both.
So why then can a request for reinvestigation stall the running of the prescriptive period, but a request for reconsideration does not?
A reinvestigation, which entails the reception and evaluation of additional evidence, will take more time than a reconsideration of a tax assessment, which will be limited to the evidence already at hand. This justifies why a request for reinvestigation can suspend the running of the statute of limitations on collection of the assessed tax, while the request for reconsideration cannot.
So what was the nature of the protest letter then? Is it a request for reconsideration or a request for reinvestigation?
The protest letter filed by BPI was in the nature of a request for reconsideration because such letter did not request to raise any question of fact, neither did it offer to present any new evidence. In fact, the BIR already treated the letter as a request for reconsideration. Therefore, the protest letter did not toll the prescriptive period for the BIR to collect on the assessment it made in 1989 regarding the sales transaction between BPI and the central bank. Now, since BIR waited for 7 years to deny the protest letter, the prescriptive period has expired and BIR can no longer collect.
Like the BRR forgot the age-old phrase that time is gold. It should have replied to the protest letter right away. So we learned that a request for reinvestigation tolls the prescriptive period. Now, note, however, that the mere filing of a request for reinvestigation does not immediately toll the running of the statute of limitations. Article 224 of the Tax Code of 1977, as amended, very plainly requires that the request for reinvestigation must be granted by the BIR Commissioner to suspend the running of the prescriptive periods for assessment and collection.
Yes, in short, the act of requesting a reinvestigation alone does not suspend the period. The request should first be granted in order to effect suspension.
That is the same decision made in the case of CIR versus United Salvage and Towage in 2016. It's quite complex, but the case also spoke of investigations and the statute of limitations for tax collection. In this case, United Salvage and Towage received assessment notices for various taxes, and they contested the validity of these assessments, arguing that they lacked legal and factual basis. So United Salvage filed a request for reinvestigation on March 14, 1997, and the CIR granted the request on January 22, 2001.
So basically, it took them 3 years to grant the request for reinvestigation.
Exactly. On top of that, the Court of Tax Appeals held that the preliminary assessment notices for deficiency expanded with withholding tax for certain years were not formally offered as evidence, and therefore couldn't be considered. The final assessment notices for other years were declared void because they didn't specify the legal and factual basis for the assessments as required by the tax code.
So, what was the final outcome of this case?
The Court of Tax Appeals ruled that United Salvage Towing's right to collect the deficiency and the withholding tax on compensation for a specific year had already lapsed due to the statutes of limitations. The Court of Tax Appeal and Bank affirmed this decision with the modification that the assessment for another year was upheld.
So, clearly, the act of requesting a reinvestigation alone does not suspend the prescriptive period. The request should first be granted in order to effect suspension. Too bad they granted the request beyond the prescriptive period.
Speaking of the tolling of prescription, it also read about it was decided in the case of Talento versus Escalada that it deals with the tax collection and legal remedies. The key issue was whether the collection of taxes can be suspended when a taxpayer files an appeal and posts a surety bond. The case involves Petron Corporation and a dispute over a real property taxes.
And what was the court's ruling on that issue?
In this case, the court acknowledged the general principle that taxes are essential for the government and that filing an appeal usually doesn't suspend tax collection. However, there's an exception, which is when a taxpayer can show a clear and unmistakable right to hold off tax payment. In this case, Petron contested the assessment and posted a surety bond which was equivalent to the amount of the assessment. So in this case, the court also held that Petron had valid reasons to contest the assessment and the issues needed to be resolved before the government could proceed with the sale of the Petron's properties.
So that means that the rule that an appeal of an assessment does not suspend the collection of realty taxes has an exception. That is when the taxpayer has shown a clear and unmistakable right to refuse or to hold in abeyance the payment of taxes, as when he was able to post a surety bond equivalent to the taxes assessed against him.
Yes, that's correct.
Yes, that makes sense. So listeners, this is very important. It's a balance between the government's need for revenue and the taxpayer's right to challenge assessment. Let me repeat that because this is very important. It's a balance between the government's need for revenue and the taxpayer's right to challenge assessments.
Yes, I guess our listeners took that to heart. No? So, to summarize, we learned a lot of ways as to how the statute of limitation will not apply. First is when the government and the taxpayer execute a valid waiver executed in accordance with paragraph D of section 223 of the Tax Code of 1977. The requisites of a valid waiver have been discussed a while ago. And
The second way to suspend the statute of limitations is when a taxpayer files a request for reinvestigation and that request has been granted by the BIR commissioner.
Yes, the third is when a taxpayer has shown a clear and unmistakable right to refuse or to hold in abeyance the payment of taxes as when he was able to post a surety bond equivalent to the taxes assessed against him.
The fourth way is when the taxpayer is held to be in estoppel. So even when the request for reconsideration or reinvestigation is not accompanied by a valid waiver, or there is no request for reinvestigation that had been granted by the BIR commissioner, the taxpayer may still be held in estoppel and be prevented from setting up the defense of prescription of the statute of limitations on collection when, by his own repeated requests or positive acts, the government had been, for good reasons, persuaded to postpone collection to make the taxpayer feel that the demand is not unreasonable or that no harassment or injustice is meant by the government.
Right. And lastly, the statute of limitations may also be suspended when the taxpayer files a false or fraudulent return with intent to evade tax or when he fails to file a return. Here, the tax may be assessed or a proceeding in court for the collection of such tax may be filed without assessment. This is going to be done at any time within 10 years after the discovery of the falsity, fraud, or omission. Provided, however, that in a fraud assessment which has become final and executory, the fact of fraud shall be judicially taken cognizance of in the civil or criminal action for the collection thereof.
So we've been talking about the prescriptive period for when the CIR or the BIR can assess and collect taxes. Now, what if a taxpayer pays more than what was legally due for him or her? Can the taxpayer claim for refund?
Yes, of course, definitely they can. However, this claim must be filed on time. Otherwise, the money paid in excess becomes the property of the state.
So, when should the taxpayer file a claim for refund?
The Supreme Court actually educated us on that matter through the case of CIR versus Dash Engineering Philippines. So Dash Engineering Philippines Incorporated, or DEPI for short, filed its monthly and quarterly value-added tax returns for the period from January 1, 2003 to June 30, 2003. Now, in 2004, DEPI filed a claim for tax credit or refund in the amount of 2 million, representing unutilized input VAT attributable to its zero-rated CEOs. So because the CIR failed to act upon the said claim within the prescribed 120-day period to deny or grant the claim, DEPI filed a petition for review with the CTA on May 5, 2005. Now, CIR questioned the filing of the petition, and they argued that the filing of the judicial claim for refund was filed out of time. DEPI should have filed a judicial claim for refund within 30 days after the lapse of the 120 days or until January 6, 2005. The petition filed by DEPI was actually filed on May 5, 2005.
Wait up. You said that the CIR failed to act upon the refund claim of DEPI within 120 days. So why didn't DEPI follow up his claim with the CIR instead of filing a case with the Court of Tax Appeals?
Well, that is because when the CIR failed to act or decide on the refund claim within 120 days from the date of submission of the application for refund, that amounts to a denial of the application by the taxpayer. So when the 120-day period expires, or when the CIR denies the claim of the taxpayer may appeal the decision or the enacted claim with the Court of Tax Appeals.
I see. So now that's understood. So did DEPI file its judicial claim for refund with the Court of Tax Appeals on time then?
No, the answer to that is in the negative. Section 112D of the NIRC provides that upon the inaction of the CIR for 120 days, after the submission of the documents in support of the claim, the taxpayer has to file its judicial claim within 30 days after the lapse of the said period. In this case, DEPI filed its administrative claim for refund with the BIR on August 9, 2004. And that is 120 days after August 9, 2004 is December 7, 2004. Now, since the CIR failed to decide on the case on December 7, 2004, DEPI had 30 days therefrom or until January 6, 2005 to file a petition for review with the CTA. Unfortunately, DEPI only sought judicial relief on May 5, 2005, despite having ample time to file the same, which is it's almost 4 months after the period allowed by law. So as a consequence of DEPI's late filing, the CTA did not properly acquire jurisdiction over the claim.
Yes, to add to that, it is important to note that the 120-day period for the CIR to decide on the administrative claim and the 130 days for the taxpayer to file a judicial claim is mandatory and jurisdictional. Therefore, failure to comply with the 120 plus 30-day period would deprive the CTA of its jurisdiction to entertain the same.
All right. We have been discussing assessment. So, in the exercise of the government's right to assess, can a revenue officer conduct an examination or assessment any time of the day or night?
So no, a revenue officer cannot conduct an assessment anytime. It was discussed in the case of CIR versus Sony Philippines and CIR versus De La Salle University. So it was emphasized that there must be a grant of authority before any revenue officer can conduct an examination or assessment. A letter of authority or LOA, it is the authority given to the appropriate revenue officer assigned to perform assessment functions. So it enables the said revenue officers to examine the books of account and other accounting records of a taxpayer for the purpose of collecting the correct amount of tax. Equally important is that the revenue officer authorized must not go beyond the authority given. So, in the absence of such an authority, the assessment or examination conducted is null.
In the case of CIR versus Sony Philippines, CIR had a letter of authority in conducting the assessment, but the tax deficiency assessment was invalid. So how so?
So, yes, indeed. In this case, so CIR had a letter of authority, but the revenue officers went beyond the authority given. So here, CIR issued a letter or LOA, letter of authority, authorizing certain revenue officers to examine Sony's books of accounts and other accounting records regarding revenue taxes for the period 1997 and unverified prior years. So a preliminary assessment for the 1997 deficiency taxes and penalties was issued by the CIR, which Sony protested. CIR insisted that the LOA, although it states the period 1997 and unverified priority years, should be understood to mean the fiscal year ending in March 31, 1998. So the CIR, acting through its revenue officers, went beyond the scope of their authority because the deficiency VAT assessment they arrived at was based on records from January to March 1998, or using the fiscal year which ended in March 31, 1998. The Supreme Court ruled that a letter of authority should cover a taxable period not exceeding one taxable year. The practice of issuing LOAs covering audits of unverified prior years is prohibited. So if the audit of a taxpayer shall include more than one taxable period, the other periods or years shall be specifically indicated in the LOA.
See, so does it mean that when a letter of authority is void, the assessment is automatically void as well?
So no, in the case of CIR versus De La Salle University, it was held that the LOA issued to DLSU is not entirely void, but the assessment is valid. BIR issued to DLSU a letter of authority authorizing its officers to examine their accounts and other accounting records for all internal revenue taxes for the period fiscal year ending 2003 and again unverified prior years. So BIR issued a preliminary notice to DLSU. So BIR filed BIR through a formal letter of demand assessed their taxes, tax deficiencies, and demanded payment of 17 million, inclusive of surcharges, interest, etc., for 2001, 2002, and 2003. So the LSU protested this assessment. They argued that the practice of issuing a LOA with any indication of unverified prior years is void, as the last case. So, an assessment issued based on such defective LOA must be void. So, the LOA includes unverified prior years. But this does not mean that the entire LOA is void. So the assessment for taxable year 2003 is valid because the taxable period is specified in the LOA. So the LSU was fully apprised that it was being audited for the taxable year 2003, but the assessments for taxable years 2001 and 2002 are void for having been unspecified on separate LOAs.
Okay, so I have a question then. Will a letter notice be sufficient to conduct an assessment?
So no, a letter of notice is insufficient. As held in the case of Medicard versus CIR, a letter notice cannot take the place of letter of authority. So to give a brief background, a Medicard is a health maintenance organization that provides prepaid health and medical insurance coverage to its clients. So Medicard filed a quarterly VAT returns through the EFPS, or Electronic Filing and Payment System. So upon finding some discrepancies between Medicard's income tax return and VAT returns, the CIR informed Medicard and issued a letter notice subsequently. The CIR also issued a preliminary assessment notice against Medicard for deficiencies. So a memorandum was likewise issued recommending the issuance of a formal assessment notice, or FAN, against Medicard. And then Medicard received CIR's FAN, or final assessment notice, for alleged deficiency VAT for taxable year 2006. Medicard raised the issue of lack of a letter of authority.
That's right. And to add, it was also discussed in this case that the following differences between a letter of authority and a letter notice are crucial. First, a letter of authority addressed to a revenue officer is specifically required under the NIRC before an examination of a taxpayer may be had, while a letter notice, on the other hand, is not found in the NIRC and is only for the purpose of notifying the taxpayer that a discrepancy is found based on the BIR's relief system. So second, a letter of authority is valid only for 30 days from the date of issue, while on the other hand, A letter notice has no such limitation. Third, a letter of authority gives the revenue officer only a period of 10 days from the receipt of the letter of authority to conduct his examination of the taxpayer, whereas a letter notice does not contain such limitation. So simply put, the letter notice is entirely different and serves a different purpose than a letter of authority. So due process demands that after a letter notice has served its purpose, the revenue officer should have properly secured a letter of authority before proceeding with the further examination and assessment of Medicard. Unfortunately, in this case, this was not done. A LOA cannot be dispensed with just because none of the financial books or records being physically kept by Medicard was examined.
So what then is the presumption on tax assessments?
So in the case of CIR versus Hantex trading, as a general rule, tax assessments by tax examiners are presumed correct and made in good faith. All presumptions are in favor of the correctness of a tax assessment. It is to be presumed, however, that such assessment was based on sufficient evidence. However, the correctness of a tax assessment does not apply upon proof that an assessment is utterly without foundation, meaning it is arbitrary and capricious, where the BIR has come out with a naked assessment without any foundation or character. The determination of the tax due is without rational basis.
I remember another case, or this case, the Hantex trading. Hantex trading is engaged in the sale of plastic products and imports synthetic resin and other chemicals for the manufacture of its products. The Economic Intelligence and Investigations Bureau, or EIIB, received confidential information that Hantex imported synthetic resin, but the amounts for the transactions were understated. Photocopies of the consumption entries were used as an evidence of this understatement. And so the CIR demanded payment of its tax deficiencies and maintained that these import entries were admissible as secondary evidence under the best evidence obtainable rule.
So, however, the best evidence obtainable under Section 16 of the 1977 NIRC does not include mere photocopies of records or documents. So, CIR, in making a preliminary and final tax deficiency assessment against Hantex, cannot anchor the assessment on mere machine copies of records or documents. So mere photocopies of the consumption entries have no probative weight. It offered no probative weight if offered as proof of the contents. So the reason for this is that such copies were mere scraps of paper and are of no probative value as basis for any deficiency income or business taxes against a taxpayer.
Well, again, assessment must be based on based on actual facts.
All right. Thank you, everyone, for sharing your ideas for tonight's discussion. And as much as we want to continue to delve more into discussing certain matters regarding our tax laws, our limited airtime prohibits us from doing so. We then hope that our listeners have learned a lot from tonight's discussion. There were many or madami kaming na-discuss via, from the structures and powers of the BIR, assessment, evidence required during assessment, prescriptive period, doctrine of estoppel, requisites of valid waiver of statutes of limitations, and more. So I hope that during the entire discussion, you were there with us. And once again, I thank my friends for um, joining us in today's tax talks. So Do you want to reiterate on certain matters that are quite important and should be noted by our dear viewers?
I think rather than reiterating stuff, I would wanna see what everybody's biggest takeaway is from today's session. Like what stood out of we've covered a lot of topics today. But for you personally, what stood out? Because let me go ahead. Let me go first. So for me, I would say it would be the requisites for the waiver, because we would think
Mhm.
that once you execute a waiver, hello, from the definition of waiver alone, you're waiving your rights. So I would
Mhm.
think that would be enough, but apparently, given the numerous cases that was discussed today, it it definitely has a lot of requisites, and I wouldn't go over all six of them. I just know that there are six. But again, we need to take note of that whenever we're executing a waiver as taxpayers. That's for me. How about you guys?
I would want to hear from you, Miss Dawilan, ma'am.
Yeah, my takeaway would be for the prescription of taxes. So that we heavily discuss on those, right? And there's like
Mhm.
numerous ways to waive those statute of limitations prescribed by law. So definitely that is justified because again, to stress, a waiver of the statutes of limitations is a derogation of the taxpayers' right to security against prolonged and unscrupulous investigations by the government. So the taxpayer should be allowed to not think anymore of the BIR having to investigate their books, their accounts. So that is why the prescription is there. However, of course, for waivers, that should again or that should be still strictly construed because that is an extension of the investigation that should be done by the BIR against the taxpayer. So we should just again remember those ways to extend the prescription period, and again the ways to um what they call this suspend the prescriptive period again imposed by law. Kathy, do you have anything to say?
Yeah, of course. So my takeaway, the zonal valuation. So we know that BIR has the right to prescribe zonal valuation, right? But they cannot exercise such power without um following the rules executed by the law. So yeah.
Okay, I want also to hear from Ma'am Cariz. Do you have any takeaway for our for the discussion tonight?
Yes. So for my takeaway, as a business owner, it's really difficult to manage this type of work, like the taxes side. It's really difficult. So as a business owner, you have to know your rights, responsibilities, obligations, and such. And I discovered that I have to learn more about this so that I will not be BIR will not be after against me as a business owner. How about Sir Bon?
Okay,
I think
Yeah, the only thorn among the rose. Oh, go, Bon, take it away.
So my takeaway, you already mentioned a lot, so overtime na pag ano, if I will
Yeah,
discuss
I can.
my part.
Yes, our director is already giving us signs to wrap things up because of our limited airtime. So, once again, thank you everyone for sharing your takeaways. And to our viewers, thank you everyone for joining us, and we hope to see you again on the next episode of Talks.